Sounds good. Recording started, and we will be streaming here in about 10 seconds.
All right. Good morning, everyone. Looks like we are now on the record and video streaming, so I will call this evidentiary hearing to order. My name is Andrew French. I'm chair of the Kansas Corporation Commission, serving as presiding officer for this hearing, joined by my fellow commissioners, Commissioner Dwight D. Keene and Commissioner Annie Keither. This is docket number 25 CONS 3139 CSHO, captioned in the matter of determining the responsibility of Cyclone Petroleum Incorporated operator for the SWAM number 1 and the SWAM B1 wells in Section 7, Township 35 South, Range 3 East, Cowley County, Kansas. We are going to begin today with entries of appearance, and we will start with staff.
Good morning, and thank you, Chair French. Kelsey Marsh on behalf of Commission staff and the public generally.
Good morning, Mr. Marsh. We will now move to Cyclone.
Martin Peck appears as local counsel for Cyclone, and I'll let Mr. Hartman introduce himself.
Andrew Hartman, or Andy Hartman, and I have with me here today Mr. James Haver representing Cyclone.
All right, thank you, Mr. Hartman. And we are getting a feedback, I believe, from your microphone, so just be careful when you're not speaking to go ahead and put yourself on mute.
Okay.
Thank you.
Jim, do you have a cell phone on or anything? No. Neither do I. Okay.
And next, finally, we will move to Martin McCorgry representing himself. Mr. McCorgry, you're muted right now.
I'm just waiting to hear what happens.
Okay.
I'm in a snake pit. Thank you.
Thank you. All right. We will now move to a brief discussion of notice of this proceeding. Does staff have a recommendation regarding notice?
Yes, on October 27th, 2025, the presiding officer provided notice by filing an order setting evidentiary hearing, wherein an evidentiary hearing was scheduled for Thursday, December 11th, 2025, beginning at 9:00 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties who are in attendance today. Staff recommends the commission find that notice is proper and that the commission has the jurisdiction to hear this matter at this time and place.
All right. Are there any objections to notice? Hearing none, I will find that notice is
No
proper.
objection from Cyclone. I
Thank
apologize. I'm moving slow by muting.
Sometimes it takes a minute to get on and off a mute. Hearing no objections, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let's start with a few preliminary matters. Before I ask the parties if they have any, I'll just start with a few procedural items. There are some standard reminders because we're conducting this over Zoom. We do know sometimes things can go wrong. If any party encounters a technical issue, just ask us to go off the record. We'll go into recess, we'll resolve that issue, and then we'll go back on the record. Second, witnesses are asked to keep their microphones off or muted when they're not scheduled to talk. If everyone would please mute your cell phones in your offices, other electronic devices, that would be appreciated. Third, just so the parties are aware, if the commission needs to consult among ourselves for something like an evidentiary ruling, we may go off the record and enter into what's called a Zoom breakout room to discuss, and then we'll return and go back on the record. Fourth and finally, please just be very careful to identify exactly what you're referring to when you're discussing pre-filed testimony or exhibits. I believe we have copies of everything that's been pre-filed, all the exhibits that have been circulated. So we have them on hand and we should be able to follow along as long as folks identify what they're talking about. So with that, before we move into the procedure for the hearing, do the parties have any other preliminary matters they wish to take up? Mr. Hartman, I
Chair,
see you've gone off of mute. Go ahead.
yeah, on behalf of Cyclone, we believe that the hearing would be substantially expedited if we are given an opportunity after the conclusion of the hearing and after receipt of the transcript to submit a post-trial proposed findings of fact and conclusions of law. We'd like to know whether and to what extent that will be permissible now so that we can govern ourselves accordingly during the proceeding. That's our request. And second request is we are asking that the commission take judicial notice, if you will. That's the phrase I'm familiar with. I don't appear before corporation commissions very often. Of the earlier proceedings that were instituted by the Kansas Corporation Commission against Newcomet and Endeavor Energy and some others. And there are conclusions associated with those proceedings that pertain to this very prospect and in fact pertain to this very lease that is the subject. So we're asking that judicial notice be taken of those proceedings. And then finally, I need to explain that some of the exhibits that we have submitted as proposed exhibits are from the court file associated with a private proceeding that was instituted by Endeavor and Newcomet against Cyclone Energy and other Haver entities. Those matters, I did not get certified copies of those pleadings, pretrial order, the jury verdict, etc. But we'd ask that the commission take judicial notice of the authenticity of what we've submitted and acknowledge those proceedings and consider those proceedings again in the context of our arguments in support of collateral estoppel.
So let's sounds like we've got three items. The middle one, I think, is probably the easiest one for me to go ahead and give you a ruling on now. My understanding is you'd like to take, we call it official notice or administrative notice here in our proceedings. Take official notice of some prior KCC proceedings. That won't be a problem at all. We freely take notice of our own files and records. What I would ask is, do you have a specific docket number where those proceedings take place?
I apologize, Chairman French. I do not have the actual proceeding.
If so we'll defer a decision on that for now, except for I will tell you that if you follow up with a very short motion after the hearing in writing and notify us of which KCC proceedings you would like us to take notice of, I will tell you now that will be granted.
Okay,
So
Ida, would you remind me, Ida, to do that? Thank you.
all right. As for your first request, I believe your request was that you would like to, following the proceeding, have the opportunity to file a proposed findings of fact and conclusions of law. Is that correct?
Yes, sir.
Yeah, I will go ahead and grant that as well. I don't know that we have decided whether there will be briefing in this case. The parties or John may be able to help me out there. Usually I ask about that at the end. But to me, that would be something that would be appropriate if we have a brief to go ahead and just include that with your briefing. Basically, to me, that would be a proposed order for us in this case, and I think that would be appropriate. We would have no problem with that, and I would say that that would go for all parties if they want to go ahead and prepare a proposed findings of fact and conclusions of law for our consideration. We would create the opportunity for anybody to file that.
Thank you.
And
That will substantially expedite the proceeding in my mind. Thank you.
very good. And then as to your last request, I understand that you were describing that you have a number of exhibits, some of which are um, records of court proceedings. To the extent those are public documents or official documents, even if they're not certified, um, we will probably be willing to take official notice of those. I understand that is not the entire bulk of the exhibits, and I do understand there may be some objections to some of the exhibits. Was it your intent to offer all of the exhibits for admission at this time, or were you planning to do that during the course of examining witnesses?
Well, quite honestly, I'd like to do it at this time, just so that, again, to expedite things rather than going through the procedural uh, uh, process during the examination, which oftentimes takes people's train of thought off the path.
Yeah. Well, if you are prepared, I think we would be willing to go ahead and do that. I do know that it does add some difficulty because it you may have difficulty laying foundation for some of them, although if there are no objections to some, then it may not be a problem. But why don't we go ahead and try? And if you would describe your exhibits, and then we will ask the other parties if they have any objections. I'm always in favor of expediting the proceeding to the extent we can. If we can't, that's how it'll be, and we'll have to move into the examination of witnesses. But let's go ahead and see what you have and see what the other parties' responses are.
So Ida, would you pull up Exhibit 116 on the screen, the first page, which is the petition that was filed in case number 15 CV 81 in the District Court in Fort Sumner County, Kansas? It's our contention, and Mr. Haber, is this a true and correct copy of the petition that was filed by Endeavor and Bradley Bates and Joe Driscoll and Newcomen Exploration against Cyclone Petroleum and other Haber entities on or about the 12th day of August 2015?
Yeah, yes.
And
Mr. Hartman, I don't know that it's necessary to ask the foundational questions now.
okay,
If
then
there isn't any objection, and the only reason I've got an issue with it is we haven't sworn your witness in, so so I'm
That's
not sure
fine.
that the testimony works. So if you would just
Okay,
describe each of them, and if there are objections, then maybe we'll wait until we get to the examination portion.
okay, and I apologize.
No, you're all right.
The and just by way of jumping back for a moment, the Corporation Commission proceeding that was the subject of the proceeding by the commission against Endeavor is docket number 15-CONS-442-CMSC.
Okay, thank you very much. We will take official notice of that in this proceeding.
Right. And
Well,
so the
I
first,
wonder if to speed this up, I do understand that you have already circulated your exhibits and marked them, and I think staff has seen them. If I could just ask at this time for you to list the exhibits, and then maybe we could just ask the other two parties whether they have any objections to any of the exhibits. That would maybe let us go ahead and expedite the ones that there are no objections to. Does that work for you?
yes, that's great. So Haber Trial Exhibit 116 is the petition that was filed in the Endeavor case against Cyclone and other Haber entities. Exhibit 117 is the pretrial order in that case. Exhibit number 118 are the instructions by the court to the jury in that case. And Exhibit 119 is the verdict rendered by the jury in that case. And we contend that all of those documents are relevant because they all deal with the Swaim lease and whether and to what extent Endeavor was responsible for the plugging of a well on the Swaim lease, or actually all the wells on the Swaim lease, is our contention. And that's the reason that we submit.
Are there any objections to taking notice of those court documents?
Yes, Chair Branch. The documents are not relevant. The Swaim 1 and Swaim B1 are never referenced in any of those documents. The district court case, as far as I can tell, was civil litigation between Cyclone and Endeavor about Endeavor attempting to recover damages in the form of plugging expenses for the wells that, like I said, are not part of this present matter, and then recovering attorney's fees based on a contract entered between the two parties. There's no reference to either of these wells in those documents, and I don't see how they are relevant in any sort of form or fashion.
All right,
May I
thank you,
respond?
Mr. Marsh. Yes, you may.
The case referenced the plugging obligation on leases. It's not necessary that the wells themselves have been identified, these two wells that are the subject of this proceeding, because it pertained to the commitment on the part of Endeavor to plug the wells that were located on the leases that are in exhibit to this assignment and sale agreement. And the Swaim lease was one of the leases listed therein, and therefore it is relevant and appropriate in the context of this proceeding.
So what we're going to do, I understand the objection and the argument, but because these are appear to be reliable court records, we are going to go ahead and take notice of them, admit them into the record as exhibits. The commission will give them after review and after review of the testimony taken today, we will determine the weight at that time that we give them. So all that to say, we will overrule the objection and we will admit the exhibits. Mr. Hartman, if you will proceed with additional exhibits, if
Yes,
you
sir.
have any.
Yes. Ida, could you put up exhibit 120 on the screen?
So, and just for clarity of record, we have admitted 116, 117, 118, and 119.
Thank you. Exhibit 120 is recorded in the records of Cali County, and it is the assignment and bill of sale from Endeavor to Redbud Energy Partners, where Redbud Energy Partners assumed all plugging obligations associated with the Swaim lease. And the date of that agreement was April 1 of 2022. We contend that it's relevant because this is an assumption, a written assumption of an obligation to plug all wells on the Swaim lease by Redbud Energy Partners.
Any objection on this item?
Yes, Chair French. Objection. I mean, I think there's a lack of foundation here. We're talking about a contract in between Endeavor and Redbud. I don't believe either of those parties are here today. Second, I go back to objecting based on relevance. I'm not sure that this document, which is a contract, has any relevance whenever, KSA 55-179 pretty well lays out potentially responsible parties for abandoned wells.
Any response?
Yes, Kansas Statute 55-179 B3 specifically says that a party that most recently accepted responsibility for the well by accepting an assignment or by signing an agreement or other written document between private parties in which the person accepted responsibility. In this case, Redbud has accepted responsibility and is obligated to plug these wells that are the subject of this proceeding. And it's relevant in the context of the fact that the commission staff has chosen not to pursue Endeavor or Redbud when they are clearly responsible parties under private agreements.
And this agreement is on record. It's been
Yes, sir.
recorded.
It's filed of record in the records of the county court.
All right. We will overrule the objection and we will admit this exhibit. And again, understand the objection on relevance. The parties can discuss that in examination of witnesses today. They can discuss that in briefing, and the commission will make a determination of relevance and give this document the weight it's due. But at this time, it is admitted into the record. So Exhibit 120 is admitted.
The the um the other, I believe that um the other documents that I believe have been included in our exhibits that were not a part of, well, let me just go ahead and address it. Exhibits 112 and 111 are business records, contemporaneously kept business records in the form of email between Mr. Haber and representatives of Newcomet and Endeavor, where it is clear that Newcomet and Endeavor were aware that there were 4 wells on this Swaim lease and not just 2 wells on the Swaim lease. And we think that's relevant in the context of their knowing acceptance of the obligation to plug these wells pursuant to the agreement between the Haber entities and Newcomet Exploration, which is Exhibit 114.
Staff.
Yes, Chair French, staff would object to these exhibits. I guess staff sees these exhibits as additional direct testimony. The emails are from 2011, and there's no reason they could not have been included with Cyclone's direct testimony. So I think that that should be not allowed here.
Yes, I'd like a response, Mr. Hartman. I had the same question. These seem like the type of thing your witness could have provided at the time you prepared your written testimony, your written pre-filed testimony in this case. What is your response?
Well, this goes to the rebuttal submission by Mr. I think it's Patterson, or no, Hoffman, by Mr. Hoffman, which in Mr. Haver's original declaration, we believe that it was clear that Mr. Haver and Cyclone did not assume any plugging obligation, as evidenced by the terms of the assignment and as evidenced by the terms of the original lease. Mr. Hoffman has submitted a rebuttal to that testimony, and part of that rebuttal is a contention that that there was no change of operator form filed. We think that's irrelevant because Cyclone was never the operator of the 2 wells that are the subject of this controversy. And there's also allegations in terms of what Endeavor and Newcomet did or did not know at the time that they took on the obligations in the subject wells pursuant to the assignment agreement between the parties. So we didn't think we were going to have to address the issue of Endeavor's knowledge.
Why don't we do this? Sorry, I'm getting feedback again. I'm going to mute you. I apologize. Here's my ruling, and that is that we're gonna take this one under advisement for now. We're gonna defer a ruling on whether this exhibit it's exhibits 111 and 112 we're going to defer a ruling on whether to admit them at this time. However, if you would like to use them in your cross-examination of Mr. Hoffman, perhaps to lay some foundation, that is certainly welcome, and you could ask for admission at that time. It is also possible that the commission, after today's hearing, in our final order, we may make a ruling on whether these exhibits are in or out. So I'm not going to make a ruling at this time. It sounds like they are something you would like to ask Mr. Hoffman about. And so I would go ahead and welcome you to use those as demonstrative exhibits or illustratives during your examinations. The commission will make a determination later as to whether we actually accept those documents into the record as evidence. Is that clear for everyone?
Yes,
All
sir.
right.
Thank you.
Are there any additional exhibits, or are we at the end of?
That's all we have at this time in terms of pre-admission.
Okay, thank you very much. Any other preliminary matters from the parties before we turn to opening statements? All right, I'm not hearing anything. So regarding the procedure for this hearing, the parties are typically allowed to make opening statements. After those opening statements, we'll have examination of the witnesses. After direct examination of the witnesses, there will be an opportunity for cross-examination by the other parties, commissioner questions, and redirect. Any further examination would just be at the discretion of the commission. Following witness examination, we will allow closing statements for those wishing to make them, and we will arrange for the filing of post-hearing briefs if necessary. And I will note that Mr. Myers has informed me that there has been an agreement on a briefing schedule. So that will be, we'll make sure to cement that at the end of the proceeding.
And Chair French, I apologize. I just want to make sure I'm 70, so my memory is not as good as it once was. I believe staff has stated that they don't anticipate any objection to exhibits 101 through 110, and I just want to make sure that those have been pre-admitted, and I can't remember whether we addressed that or not.
I don't believe we discussed those. Mr. Marsh, did you have any objection, or Mr. McCorgry, did you have any objection to those exhibits?
I did not.
Okay. All right. Hearing no objection, we will admit the exhibits 101 to 110, which I believe were circulated ahead of the hearing. All right. Let's move into opening statements to the extent the parties would like to make them. And I will begin with Mr. Marsh from Commission staff.
Thank you, Chair French. May it please the commission. The issue before you in this matter is who is responsible for two abandoned wells, the Swaim number 1 and the Swaim B number 1. Staff believes the documentation filed in the docket to date and the evidence provided today shows that Cyclone and/or Mr. McCorgry are responsible parties for these wells. Staff requests that whoever the commission determines to be responsible for these wells be required to promptly plug the wells or bring the wells into compliance with the commission's rules and regulations. Thank you.
All right. Thank you, Mr. Marsh. Mr. Hartman, do you have an opening statement?
Yes, sir, I do. Chairman and commissioners, thank you for the opportunity to present evidence here. Ida, would you please pull up Exhibit 105 and display it on the screen? So we believe the evidence will be that under the KGS oil and gas well database information available, there were 4 well bores on the Swaim lease. Those well bores have API numbers ending 23624, which is one of the wells that is the subject of this proceeding. API 23678, which is not the subject of this proceeding, but which was plugged and abandoned by Endeavor Energy Resources pursuant to an order of this commission, which required them to plug because they had assumed plugging responsibility in the case. Then there is API number 23712, which is a part of this proceeding, which is an inactive gas well. And as you can see from the total depth, is only 790 feet deep. So it was clearly some kind of coal bed methane play or something like that, but was not an oil well. And then there was the Swaim Sundance number 7, which was a well that was in fact drilled by Cyclone Petroleum back in September of 2002. And we believe that that evidence will also then support Exhibit 110. Ida, would you please display Exhibit 110? We believe that the evidence will be that this, and this is admitted into evidence, that this map accurately reflects the 4 wells that were referenced in Exhibit 105 that was previously addressed, that the 2 wells that are the subject of this proceeding are the Swaim number 1 API 23624, which is in the most upper left well, the Swaim B1 API 23712, which is in the upper right hand corner. Those are the 2 wells that are the subject of this proceeding. The 2 wells at the bottom, this one on the left to the west, the Swaim Sundance 7 API 24169, is a well that was drilled by Cyclone and was producing, I believe, at the time that the transfer took place from Cyclone and the Haver entities to Newcomet and Endeavor. And the well Swaim A1 API 23678 is the well that was required by the KCC to be plugged by Endeavor, and it was in fact plugged by Endeavor in September of 2016. That very same well was part of the litigation that was filed by Endeavor against Cyclone, in which a jury verdict returned saying that no, Cyclone did not have any liability and none of the Haver entities had any liability to Endeavor because Endeavor assumed the obligation to plug the wells on the Swaim lease. That litigation, as Mr. Haver will testify, was not limited to certain well bores. It was defined by the leases that were the subject of the transfer by Cyclone and the other Haver entities to Newcomet and Endeavor. When we look at the statutes, and Ida, would you please display the opening statement statute that I gave you with the highlighted in yellow? According to Commission's letter, which is our Exhibit 1, the Commission is proceeding against Cyclone based upon KSA 55179B2 and KSA 55179B3. It is not proceeding under B1, B4, B5, or B6. So we focus during this proceeding on B2 and B3. If you look at the language of B2, it says that a responsible party is the most recent operator to produce from or inject or dispose into the well. There is no evidence, and there can be no competent evidence, that Cyclone or any of Mr. Haver entities ever operated, injected, disposed into, or produced from the 2 wells that are the subject of this proceeding. It then goes on to say, but if no production or injection has occurred, and we have no knowledge of whether production or injection had ever been incurred, the person that caused the well to be drilled is the responsible party. It goes on to then say, a person shall not be legally responsible for a well pursuant to this paragraph if the person can demonstrate that the well was physically operating. We contend that that's irrelevant because Endeavor knew of the existence of these 4 wells on this lease. Haver did not produce or inject or touch these wells during the time period that he had access to the lease. Therefore, Cyclone and the Haver entities have no liability under B2. We believe the evidence will also be that the claims of commission staff under B3 cannot be supported with evidence. B3 provides the person that most recently accepted responsibility for the well by accepting an assignment, that's an assignment of a lease, or an assignment of a wellbore, or by assigning an agreement or other written document. It requires a written document between private parties in which the person accepted responsibility. Importantly, it goes on to say, accepting an assignment of a lease, obtaining a new lease, or signing an agreement or any other written document between private parties shall not, that's a declaration, not may not, but shall not, in and of itself create responsibility for a well located upon the land covered thereby, unless such instrument adequately identifies the well and expressly transfers responsibility for such well. If you look at, and Ida, would you please put up the assignment, which is Haver Trial Exhibit 104. This is the assignment of oil and gas lease wherein Martin McCorgry assigned the lease to Sundance Oil and Gas. And as you see down there in the yellow highlighting, it says, and for the same consideration, the assignor covenants with the assignee, its heirs and its successors and assigns, that the assignor is the lawful owner and has good title to the interest above assigned in and to said lease, estate, and rights and property, and this critical language, free and clear from all liens, encumbrances, or adverse claims, that said lease is a valid and subsisting lease on the land above described, and all rentals and royalties due thereunder have been paid, and critical language, and all conditions necessary to keep same in full force have been duly performed. Now, in the oil and gas lease, and Ida, if you would put up Trial Exhibit 103, this is the original lease from Swain to McCorgry. And interestingly, I hope you'll note that the date of the assignment was first day of August 2002. The date of the original lease was July 22nd of 2002. So this is like 8 or 9 days. The oil and gas lease was signed, and then 8 or 9 days later, the assignment of oil and gas lease. We believe the assignment of oil and gas lease from McCorgry to Sundance was obtained by a leasing agent by the name of Robert Morgan. It was not obtained by Mr. Haver. Mr. Haver will testify that he never saw the oil and gas lease and was not aware of any provision of the oil and gas lease that required the drilling to be done until 3 existing wells are produced or plugged. He spudded the Sundance 7 the 26th of September of 2002, approximately 30 days later. And as a consequence of all this, because he thought under the assignment that he received that there were no obligations or liabilities that were being assumed, he did not and was not aware of any obligation at all. To the extent Mr. McCorgry testifies verbally that such an agreement exists, number one, it does not satisfy the requirements of the statute under B3 because it requires a written document. Number two, under known principles of law of merger, to the extent that there is some obligation of any kind, it is all merged into the final document. This assignment does not include any obligation to plug any wells, and therefore any obligation that might have been orally entered into, and we contend no such agreement ever existed, it then disappeared under merger principles. Also, any testimony concerning what the parties negotiated prior to the assignment is not even admissible under the parole evidence rule, and also would not be enforceable under the statute of frauds because this pertains to a written to real estate. As a consequence of all that, we contend that staff cannot support with credible evidence their contention that Cyclone or any of the Haber entities have any responsibility to plug these wells. Thank you for your time.
All right, thank you, Mr. Hartman. Finally, Mr. McCorgry, you do not have to, but do you wish to make an opening statement? I know you said you're just here to see how it turns out.
Well, I don't know who this, I'm not sure who this Mr. Morgan is. The northeast quarter of Section 7. He did the same thing. Jim Haver found out I had that Swaneway, so I purchased it, and he come to me wanting it. I've never heard of a Morgan. He may have sent him later, but Jim Haver personally come to me. He has personally laid a line across my property that he did not have permission on. I told him not to. He said, well, see if you can get permission. And I said, no. The deal was he had to bore an 18-inch pipeline twice within about 100 yards. And he chose to cut across my property. In 2005, I believe, no, 2002, they replaced a bridge here at my house. Their gas line was attached to the bridge. The county said, after we get the bridge done, you can put the line across the bridge, but you cannot attach it. So they come to me and wanted to lay a line on me. And I said, no. They said, well, can we have permission until the bridge is done and we'll work something out with the county? I said, yeah, that's fine. They laid a line and didn't bury it. I said, shit, I go in there every day feeding cattle, this and that. I'm going to tear your line up. So they come in and buried it with the thought that they would come back. My feelings that they was coming back to put it across the bridge. The line is still buried there today. I'm sorry, that's it.
Thank you very much. All right. Looks like we have concluded opening statements. Let's see. At this time, let me just check. Mr. Myers, we lost you for a moment. Are you back with us now? I see your name.
I am, yes.
All right. At this time, I believe it's time to start moving into witnesses. But I am going to take us into a 5-minute recess. I'd like to refill my cup of coffee. So we are now off the record. We're going to stand at ease for 5 minutes, and we will be ready to begin the examination of witnesses at 9:50. All right, I've got 9:50, so our brief recess is over. We are back on the record in the evidentiary hearing in this proceeding. We will begin with the examination of witnesses, starting with staff's witnesses. And let me just make sure we've got everybody back here. I see Commissioner Keen's. Can you confirm you're back, Commissioner Keen? Looks like we may still be waiting on him. Mr. McCorgry, can you confirm that you're back? All right, let's stand at ease for another minute here, and then we'll see if we've got everybody back. That's always the risk in giving people only a 5-minute break. Okay, it looks like we have Commissioner Keen. Mr. McCorgry, do we have you? Not yet. Let's continue to hold.
There I am.
There we go.
All right, very good. Okay, I think we have everybody back. Apologize for the very short break. But we are now back on the record and we are ready for the examination of witnesses, and we will begin with staff. Staff, you may call your first witness.
Thank you, Chair French. Commission staff calls Jeff Clock.
All right, good morning, Mr. Clock.
Good morning.
If you would, we don't have a court reporter with us this morning. We're recording, but that means you have the honor of being sworn in by me. So if you will, please raise your right hand. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Marsh, you may proceed.
Thank you. Please state your full name for the record.
My name is Donald Jeffrey Clock.
Mr. Clock, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission. I'm currently the District 2 supervisor. District 2's in Wichita, Kansas.
Are you the same Jeff Clock who caused to be filed in this docket direct testimony consisting of 8 pages and 9 exhibits on June 9th, 2025?
Yes,
Do you have any corrections to make to your testimony?
I do. I do have a correction to an API number in my pre-filed testimony. That'll be on page 3, line 11. The Swain B1 API number was incorrect. That should be read 15-035-23712. And I believe that's the same API number that Mr. Hartman had.
Thank you. Do you have any other corrections?
Not at this time, no.
Okay. Do you swear the answers contained in your pre-filed testimony with those corrections included are true to the best of your knowledge?
Yes.
At this time, staff moves for Mr. Jeff Clock's pre-filed testimony and exhibits to be admitted into the formal record.
Any objections? Hearing none, the reference testimony will be admitted.
All right. Thank you. Staff tenders the witness for cross-examination.
All right, thank you. Mr. Hartman, do you have any cross-examination for this witness?
No.
Okay. Mr. McCorgry, would you like to ask any questions of this witness?
Say it now.
No.
Okay. Commissioners, do you have any questions of this witness? Commissioner Keither? No? Commissioner Keen, do you have any questions for Mr. Clock? It looks to me like Commissioner Keen's video is frozen, so we may have lost him. Commissioner Keen, you may need to turn off your video or drop and come back. In the meantime, maybe I'll call on myself. Mr. Clock, good morning. How are you?
Good morning.
Good to see you. I'd like to ask you, I guess, sort of a very broad question here. If it's more appropriate to defer to Mr. Hoffman, I think it's for you, but feel free to defer to him. Um, what I understand from Cyclone's representations is, um, not a denial that they are involved in the chain of operating or being a lessee here, um, or that they maybe had some responsibilities at one point in time, but there seems to be a contention that there have been subsequent operators that took on these responsibilities. And and you can tell me if I'm wrong, but they seem to be asking the question, why has staff not sought to bring in some of those subsequent operators? Why has staff focused on Cyclone as the operator responsible here? In your work of looking and determining in the records of, the chain of responsibility, why did you focus on Cyclone, and why did you not identify any of these subsequent operators that they've discussed? I'm not going to pretend that I remember all of the names, but I know there was, I believe Sundance was before them, and Endeavor, and can't even remember all the other names. But why is it that you focused in on Cyclone? Presumably, some of these other operators are also licensed Kansas operators. Why is it Cyclone that staff believes is the primary responsible entity?
Right. So the district office originally received a complaint from the landowner, Mr. McCorgy, of these wells on the property. Our field technician for the area did an inspection, and at the time we did recognize that Endeavor was the operator of that lease. If you will take a look at, excuse me, I don't have the exhibits memorized.
Take your time.
Exhibit JK1. I don't know if that's something that John will bring up on the screen.
I can, yes. Chair French, would you like me to do that?
Yeah, John, if you're able, can you bring up
Yep,
Mr.
one
Clark's
moment.
exhibit? I think it's a field report, correct?
It is a field report. And I'm just trying to get to your question, why we're focusing on the parties today. So this field inspection was done by Dwayne Kruger, our field technician for the area at that time. Mr. Kruger has retired from us, but as you can see from his work right here, he did I believe meet with Mr. McCorgy. He did identify the three wells at this time in 2020 that were abandoned. You'll see that it also, the very first well shown there down in the findings box, the Swaim Sundance 7, that well was on Endeavor Energy Resources well inventory at the time. The Swaim number 1 and the Swaim B number 1 were not on their well inventory. So the field report does say Endeavor Energy Resources, and we did recognize that they were the operator of the lease. But upon reaching out to Endeavor Energy Resources, they were clear with staff that they did not own or operate the Swaim number 1 or the Swaim B number 1, and so that's when I did at the time go to the courthouse to obtain courthouse records for legal staff, that they had asked for those records, and so that's why. And your question was, why are we focusing on these operators here today? And that's why, because the original lease that Mr. McCorgy had signed did identify the abandoned wells at the time, and these two wells in Mr. Kruger's field report, the Swaim 1 and the Swaim B1, were subject of that initial oil and gas lease.
Were those when the lease was eventually made to Endeavor, refresh my recollection, were those abandoned wells specifically called out in that transaction, or they were not called out in that transaction?
I can speak to their T1, their transfer of operator. And if we can go to, that will be exhibit JK7, pages 1 and 2. There we go. So this is the transfer from Cyclone Petroleum to Endeavor Energy Resources. You can see in the upper right, the effective date of transfer was September 1, 2011. And if you take a look at the upper left, we're transferring 2 gas wells. It is noted we're transferring 2 gas wells from Cyclone to Endeavor. If we could go to the second page. Thank you. You will see that it lists the 2 wells referenced from page 1. The first one should actually be the Swaim A number 1. That API number 23678 does correspond to the Swaim A1. And the second is actually, I think we all know it as the Swaim Sundance 7, with the last 5 digits of 24169. So those were the 2 wells that were taken by Endeavor. The other 2 wells did not appear on Endeavor's well inventory after this. And so to answer your question, why we're focusing on the parties here today is because Endeavor never took responsibility via transfer for the Swaim B1 and the Swaim number 1.
I guess what I'm asking is, when they initially came to Cyclone, the abandoned wells seemed to be only noted within the lease itself. I don't believe, maybe I'm wrong, but I don't believe they were actually noted on a well inventory. And so when the transfer took place here, I guess the question to me is, was there an assignment document associated with assigning the lease for these wells, and was that recorded? Did you find that? And did it contain language assigning obligations, the same obligations that Cyclone had taken on? So not just the T1 forms, but the actual contractual assignment of the lease obligations.
I would have to go back again to, again, I believe Mr. Hartman showed it before. It would be my exhibit JK2, the oil and gas lease, the original oil and gas lease from the William Swain Trust to Mr. McCordy. That's the only document that I have that references the wells on the lease, if that's
Okay.
answering the question.
So the only the only document that contains that language about responsibility for I think it says the 3 existing wells to be plugged. The only document that references that is that original 2002 lease.
Correct.
Okay. All right. I don't believe I have any more questions. Commissioner Keen or Commissioner Keither?
Can you hear me now?
Yes, we do hear you.
Okay. I'm back from wherever I was that I was frozen in. Good morning, Jeff.
Good morning, Commissioner Keen.
Essentially, the questions I had in mind, you've asked and answered from Chair French, but I have two supplemental to his questions and your responses. The first is, and I'm not trying to put words in your mouth at all here. I'm just trying to determine what it is that is the staff's position. As I understand the staff's position, you're contending that KSA 55179B2 and B3 are both applicable in this situation. And that, as I'm understanding it, the factual basis for that stems from the fact that the original lease carved out these wells and made reference to these wells. And I'm not trying to put words in your mouth here at all. I'm just trying to understand where you're coming from. And that in the absence of some specific reference that either disclaimed that specific part of the lease, that all subsequent assignees are going to assume all rights, titles, and interests that go with the original lease and obligations. Is that the staff's position?
Yes, and I think one thing to look at in that original lease is that it also had the wording that said no drilling shall take place until these wells are produced or plugged. And so that's where staff has the position that it was Cyclone's responsibility to ensure that the wells were in compliance, because that oil and gas lease that was assigned to him specifically stated that no drilling shall take place until those wells were brought into compliance. They didn't have to plug them. They could have sought to produce those wells, but they did drill the Swing Sundance number 7.
Okay. Two more questions. Were you present in the hearing this morning when Mr. Hartman gave his opening testimony on behalf of Mr. Haver and Cyclone?
Yes. Yes.
Okay. And he gave a fairly detailed summary of the position that Mr. Haver and the company have in this particular matter. And embellished it in ways that I think were helpful in terms of trying to understand what their position is. Having heard his rendition of how he believes the facts and the outcome should evolve, do you have any rebuttal or differences of opinion that you would care to note for us at this time?
I don't. I would defer to Mr. Hoffman for any type of opinion on 55179. As you know, Commissioner Keen, I'm a licensed geologist, not an attorney. So I would defer any opinion on 55179, both B2 and B3, to Mr. Hoffman.
That's fair enough. Do you have, insofar as Mr. Hartman's summary included factual representations, do you have any differences of opinion with any of those?
No.
Would that include the fact that he is asserting that Mr. Haver, if I can phrase this correctly, did not touch or have any connection basically with these wells? Do you have any reason to believe differently than that?
No.
Okay. No further questions for me. Thank you.
Let me ask a follow-up based on an answer you gave Commissioner Keen. So, my line of questioning was, after hearing the opening from Mr. Hartman, why is staff not talking about any of the subsequent operators. I think what I heard you say is the language around the responsibility for plugging of these abandoned wells was only included in the original lease. And it was only triggered when Cyclone drilled a well. And so since they were the ones that triggered that responsibility for plugging, that is why staff is focused on them and not any subsequent operator that was assigned that lease, which also contained that same language. Is that the heart of staff's position?
Correct. Correct. The only operator to have drilled a well out here was Cyclone Petroleum.
Okay. I don't know if I have a follow-up question to that. It's probably a legal question of what that means for subsequent people that were willing to take on that lease, given those conditions. And it probably isn't fair to ask you what that means. I see Commissioner Keene's gone off of mute, so I'll turn it over to him.
I'll be very brief. My dilemma is identical to what the chair has just designated as his, because there are some legal issues here that are entwined, and I'm going to defer in asking those of others, but other than you, Jeff. So anyway, I appreciate your testimony. Thank you.
Thank you.
Thank you
May
very
I
much.
follow up?
Let's see where we are. I am going to allow redirect from staff at this time, but I may allow recross based on commissioner questions since we had pretty lengthy questioning. So, Mr. Marsh, would you like to redirect your witness?
If I may, Chair French, I have basically one question. Jeff, on your exhibit JK-8, there's an assignment and bill of sale between Cyclone and Mr. Haver's companies and New Commit Exploration. Do you remember that exhibit?
Can you repeat the exhibit number again so I can turn to it?
It's exhibit JK-8. I believe it's page 13 of 19 that I was going to start at. And I'll share my screen here real quick. Because I believe Chair French was asking about, the subsequent transfers between Cyclone and Endeavor or other operators. And if I scroll down to page 15 of 19 on exhibit JK8, is the Swaim lease listed on that page?
Yes, it is.
Okay. Are there any of the wells on the lease that are identified in that assignment?
In the header where it says Swaim, in parentheses next to it, it does say Sundance 7.
Okay. But it doesn't list the Swaim 1 or the Swaim B1, correct?
No, it doesn't.
All right. Thank you. I have no further questions.
All right. I will allow brief recross since the commissioners asked some new questioning there. So, Mr. Hartman, if you'd like to proceed with some recross.
Thank you. Mr. Clock, I believe that I heard you say that in your discussions with, one of the reasons you're not pursuing Endeavor or Redbud is that in your discussions with Endeavor, they did not include the API 23624 or API 23712 in their wellbore inventory. Is that correct?
That's correct.
Okay, on the basis of that, I'd ask that the commission enter into evidence for examination Haber Exhibits 111, 112, and 113, which make clear that Endeavor was aware of these other well bores at the time that Mr. Clock had his discussions with Endeavor, and they either mistakenly or intentionally omitted to disclose the existence of those well bores in the interview. So we'd move admission of those so that I can examine the witness.
Before we consider them for admission, why don't we publish them? So put them up and describe them to Mr. Clock.
Okay. Ida, would
And
you
then-
put up 111?
And then ask him a question about them, and then we'll consider whether we admit them.
Ida, are you there? Great. Ida,
If you
would
could
you
zoom
turn
in a little bit, that would be helpful.
Ida, if you would, this email is in reverse chronological order. So if you drop to page 3 of Haber Exhibit 111 and show the commissioners and the witness the highlighted language, which was an inquiry from Kim Dunson to Betty Hart, which is apparently internal communications, and give the witness a moment to review that. And then, if you don't mind, Mr. Clock, would you tell us when you've had a chance to review that? Because I then wanted to just take you through the chain and ask you if you have an opinion about whether Endeavor knew of the existence of these 4 well bores on the Swain lease after you've reviewed these email.
Objection.
Sorry, I didn't catch the end of that objection.
Well, I guess, there's a lack of foundation, right? Mr. Clock was never included on any of these emails, and I don't know if he's even seen them before today, so I don't know how he can provide an opinion. I guess he's already asked and answered the question because he talked about his communications with Endeavor, where they said they never took responsibility for the leases. So I'd almost say it's also been asked and answered.
Well, I don't believe that they testified. I don't believe that he said they never took responsibility for the lease. I think he said they did not have the 4 well bores on their well inventory. That was my understanding of his testimony. And I think that I have the right to examine the witness, to ask him to review these business records. Chairman specifically stated at the beginning of this proceeding that I would be permitted to use these during the course of the examination, and the decision concerning admissibility would be made after he and the other commissioners had an opportunity to hear the testimony. But maybe I'm mistaken about that.
Well, and I also see it.
Go ahead, Mr. Marsh.
Sorry, Chair French. I mean, like I said earlier, I mean, these emails were from 2011. There's no reason they couldn't have been included with the operator's direct or testimony. And I see it as publishing it now or providing it now is kind of a hiding the ball until the last minute and trying to, surprise staff or catch staff off guard, which seems to be improper in my mind.
No, we're going to go ahead and continue. So the objection is overruled. We will continue to allow an examination of the witness in light of these documents. I'm not sure if we'll be able to admit them with Mr. Clock. I may have to see where the emails actually end up coming from to figure out if we have foundation here. It may have to be through your witness, but I don't see any reason not to proceed at this time and explore the relevance of the documents. They do seem to go to rebuttal. So we will go ahead and allow you to proceed, Mr. Hartman. You may ask Mr. Clock of his understanding of these emails.
Mr. Clark, have you had an opportunity to review the email communication from Kim Dunson to Betty Hart on Thursday, December 15th, 2011 at 8:47 a.m.?
Yes, I have.
Would you now go to the response from Betty Hart that's at the bottom of page 2 on Exhibit 111 and that particular email that was at 9:12?
Oh, to Mr. Haber. Okay. And Mr. Hartman, repeat your question again on this email.
Yeah, would you take a moment and review the email from Betty Hart to Jim Haber on Thursday, December 15th, 2011 at 9:12 a.m. regarding the Swain lease? And tell me when you're done.
Yes, I'm done.
Would you now take a look at the email from Betty Hart to Travis Newcomen on Thursday, December 15th, 2011 at 12:48 p.m.?
Yes, I read that.
And if you look at that particular email, it says, Travis, do you know if Endeavor et al. Acquired the 2 Swaim wells below? All I see listed is Swaim number 1 and Swaim number 7. Doesn't it appear clear that Betty Hart at Endeavor knew that there were 4 wells on the Swaim lease?
Objection calls for speculation.
I'll let the witness answer.
I think because we have Swain names on all of these, I would like to see at least API numbers because I think there could be some confusion with just Swain number 1. The sentence says all I see listed is Swaim number 1 and Swaim number 7. I'm pretty confident the Swaim 7 is the Swaim Sundance number 7, but the Swaim number 1, is that referring to the A1 or just the number 1?
I think my question is simpler than that.
Okay.
Travis, do you know if Endeavor et al. Acquired the 2 Swaim wells below? All I see listed is the Swaim number 1 and the Swaim number 7. Doesn't that obviously lead someone to the conclusion that they're aware that there are 4 wells on the Swaim lease? Yes or no?
Yes, I could see where they would be aware of them. Yes.
Okay. Thank you. Then look at the email up at the top of page 2 of 3. This is to Betty Hart. I'm sorry. You have to look at the bottom of page 1 of 3 from Travis Newcomen to Betty Hart on Thursday, December the 15th, 2011 at 4:46 p.m. And you have to follow through on the top of page 2 of 3 to Betty Hart regarding the Swaim lease. Swaim number 1, the southwest of the southeast of the southeast, and Sundance 7 are 2 different wells. Swaim 2 is not producing. So here it's clear that Travis Newcomen knew of the existence of at least 3 wells on the Swaim lease, correct?
Correct.
Is that a yes?
Yes.
Thank you. And then look at the email just above that where Travis Newcomen sends an email to Betty Hart on December 19th at 9:35 a.m. regarding the Swaim lease. Has Jim Haber helped you solve this? And Betty Hart responds, we have set these up. We are concerning about the Swaim number 2 and the Swaim B. So they clearly know that there are at least 4 wells on the Swaim lease, and they had access wouldn't you know in your profession? They had access to well reports and the inventory of wells on the Swaim lease that exists on the Kansas Geological Survey or on the Kansas website, correct?
Yes.
So isn't it true that Endeavor, in your interview with them, either mistakenly or intentionally excluded the two wells that are the subject of this proceeding from their well inventory in their dialogue with you?
And to be clear, their dialogue was through their counsel, through Jonathan Schlatter, who and I may defer to Mr. Marsh on this, because the correspondence and conversation was through Mr. Schlatter, but he was very specific in stating that his clients at no time took control or ownership of the wells in question today.
That's not quite my question. If you don't mind, I'd like to focus on my question.
Sure.
Isn't it true that to the extent anyone communicated to staff or the commission on behalf of Endeavor or Newcomen that they were only aware of two wells on the Swaim lease, that would have been either a mistake by that representative or an intentional omission, because it's clear that Endeavor knew that there were at least four wells on that Swaim lease. Isn't that true?
Yes.
I'm sorry, your answer?
Yes. Yes. They were aware.
All right. Ida, would you please publish Haver Exhibit 113?
Thank you.
Mr. Clock, this is an email, Exhibit 113. Please disregard the fact that Mr. Haver forwarded this to me in the year 2018. But do you see that Jim Haver on October the 17th, 2011, sent a list of Cyclone pumpers to Joe Driscoll at OK Gas JD, Stephanie at OK Gas Office, and Brad B at Endeavor EERON line, Endeavor Online, a list of pumpers for the Cyclone wells, Sumner and Cali, Kansas. Do you see that?
Yes.
Okay, Ida, would you please flip to page 3 of 4 of Exhibit 113? And do you see on the list of pumpers that Sundance 7 is listed, that Pedro, that it's a gas well, that Pedro is the pumper, that there's one well, and it costs $100 a month. Do you see that?
I do.
Do you also see that down below there's a Swaim number 1 that's a gas well, that's Pedro, for which there is no charge, and then there's a Swaim number 2 that's a gas well, that's Pedro, that's no charge. Implication being there was no production. Would you agree with that?
I do.
Isn't it true that Endeavor would have known at this time that there were at least 3 wells on the Swaim lease?
So we have Swaim 1. I'm assuming the without the B, I'm assuming the Swaim 2 is referencing the Swaim B2. I'm going to assume that is the B well.
I would object because this calls for
I'm not
speculation.
even asking that you
Oh.
identify. I'm saying, wouldn't it be true that it is clear from this exhibit that Endeavor was aware that there were at least 3 wells on the Swaim lease, regardless of which ones they were? They were aware that there were 3.
Objection
Yes.
calls for speculation. There's no API numbers listed. There's no well locations listed. He's asking him to say, oh, there'd be 3 wells on the lease, but we don't know anything about where these wells are located, or, there could be duplicate names, any sort of other thing.
I'll overrule the objection. The witness can answer to the extent that he's able.
I would say that Endeavor was aware that there were these other wells out there. Yes.
Thank you. That's all I have of the witness. Thank you.
All right, thank you. Since we had some pretty extensive recross, I am going to turn back to, well, let me first make sure, Mr. McCorgry, you don't have any questions of this witness still, I assume.
Gotta unmute.
No.
Okay, thank you. Sorry, just wanted to check in. We're going to turn to commissioners to see if this has elicited any additional questions in their minds. Commissioner Keen, anything further from you?
Yes, thank you, Chair French. Can you hear me all right, Jeff? We're getting some feedback here yet.
I can hear you.
Mr. Hartman. I think that's where the
Thank you, Mr.
echo
Hartman.
went.
I think that cured it.
I can hear you, Commissioner King.
Okay, very good. Basically, 2 questions for me. The first is, given the cross-examination that you've just been subjected to by Mr. Hartman, does that cross-examination, either the documents you've been asked to opine about or any other matters, cause you in any way to change your opinion about Cyclone being, whether or not Cyclone should be the responsible party for the 2 wells of concern in this docket?
No, it hasn't changed my opinion.
Slightly different version of a similar question is then, does the cross-examination of you by Mr. Hartman cause you to change in any way your opinion about the extent of any responsibility by Endeavor for the 2 wells of concern in this docket?
No, it does not.
So there would be basically no joint responsibility that could be inferred, implied, or directly result from, in your opinion, the information that you've testified to on cross-examination by Mr. Hartman.
Well, respectfully, I would leave the joining of other parties to legal staff and to the commission. I would probably defer that. I don't know that giving a legal opinion, I think that's what you're asking me for. If joining another party is something that I believe should be true and correct, or should it just be Cyclone? Is that what I'm understanding you're asking?
I'll re-ask the question more specifically. Based upon facts, the facts as you see them, as you understand them, is Cyclone alone a responsible party for these 2 wells, or is it possible that Endeavor is also responsible?
I'm saying that Cyclone is responsible for the fact that they did drill the Swaim Sundance number 7 without bringing the other wells into compliance as was agreed upon in the oil and gas lease. That's why I do believe that Cyclone is responsible for the other wells on the lease.
Okay, thank you. No further questions.
I think I have one clarifying question, Mr. Clock. Let's assume that language about plugging the wells never existed. That sort of contingency language. Let's just assume we have a lease that's it's got some producing wells or a producing well, and it's got some abandoned wells on that property. If that was transferred and there was that other language didn't exist, regardless of whether the parties knew about the abandoned wells, or whether they were listed on any inventories, wouldn't the responsibility for those wells go along with the lease, regardless? And it is, oh, go ahead.
No, well, I don't have my dates right here. You bring up an interesting point because I'm going to go back to the quest order. Maybe council can help me out here. I'm not sure when that when that was in effect, but you're exactly right. You're pointing out something that happened in the past where wells went with the lease under which they were operated, and if this, and as we know, there was a brand new lease taken out by Mr. McCordy, that was a brand new lease. And if it didn't have that language at all in there, then Mr. McCordy would not have been under the quest order, would not have been would have been responsible at all. The chain had been broken. There was not just an assignment of these leases. If there's an assignment under the quest order, of course, you're responsible for everything out there under quest. Once you took a new lease, you bear no responsibility to those unless you touch or tampered with those wells. So I've got to be honest, 2011, I can't remember if we had that in place at the time or not, but that may have some bearing on your question to me.
So is that why it may be important, to the fact pattern here of whether Endeavor was aware of the abandoned wells on the lease?
I mean, they're aware. I mean, they were aware, going back again to Mr. Kruger's field report, where then from there we reached out to Endeavor. They were certainly aware, and their response from council was, we never owned, operated, touched, or tampered with those wells out there.
Okay. I don't believe I have any more questions. If there are no more commissioner questions, I think let's see, let me double check. I am going to give one more shot for redirect, for Mr. Marsh, if you have any additional redirect.
Thank you, Chair French. So Jeff, the assignment between Cyclone and Endeavor was dated September 1st, 2011. And those emails that were referenced by Mr. Hartman were dated December 15th, 2011. So would Endeavor have had knowledge of these wells at the time the lease was assigned?
I wouldn't be able to answer that.
Okay. Do you think that knowledge of the wells transfers responsibility for the wells?
No.
Okay. Thank you. No further questions.
All right. I think we've allowed all the examination we're going to allow for this witness, Mr. Clark. Oh, sorry, Mr. Hartman, I've muted you on accident. Go ahead.
I'm sorry. I didn't hear the answer to the last question. What was the answer to the last question that council?
Go ahead, Mr. Marsh. Can you repeat your question, and Mr. Clark repeat your answer?
Well, Mr. Clark said no, knowledge of the wells does not transfer responsibility for the wells. So my question was, does knowledge of the wells transfer responsibility for the wells? And he said no.
All right. Thank you. With that, Mr. Clark, I think we've kept you up here as long as we can, as long as we can manage. So we are going to move on. You are released and you may step down. We thank you for your testimony today. Staff, you may call your next witness.
Thank you, Chair French. Commission staff calls Director Ryan Hoffman.
Good morning, Mr. Hoffman. I'm going to swear you in. If you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Mr. Marsh, you may proceed.
Thank you. Can you please state your full name for the record and what capacity you're employed?
My name is Ryan A. Hoffman. I am the director of the Oil and Gas Conservation Division for the Kansas Corporation Commission.
Are you the same Ryan Hoffman who caused to be filed in this docket rebuttal testimony consisting of 8 pages on October 3rd, 2025?
Yes, I am.
Do you have any corrections to make to your testimony?
No, I do not.
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
Yes.
At this time, staff moves for Mr. Ryan Hoffman's pre-filed testimony to be admitted into the formal record.
Is there any objection? Hearing none.
No objection from Cyclone.
All right, thank you. Mr. Hoffman's testimony will be admitted into the record.
Thank you. Staff tenders the witness for cross-examination.
All right. We will go to Cyclone. Mr. Hartman first, if you have cross-examination for this witness.
Ida, could you pull up the statute that I used in opening statement and show it to the witness? Sir, my name is Andy Hartman. I represent Cyclone Petroleum. I have Mr. Haver here with me today. I guess I'd like to start. Am I correct in my conclusion that Cyclone is being pursued here today by staff only on the basis of subparagraphs B2 and B3 of the statute? Is that true?
Yes.
I'm sorry?
Yes.
Okay. I'd like to reference, if you would, B2 first. And the first sentence there on B2 identifies as a potentially responsible party the most recent operator to produce from or inject or dispose into the well. What evidence do you have that Cyclone or any of the Haver entities ever produced from or injected or disposed into API numbers 23712 or API 23624?
I don't have any direct evidence. It's one of the situation, the way it works is when you bring a case like this, you bring all potentially portions of the statute that would be where the operator could be found responsible. So that's why that is included.
Okay, so I want to make sure I understand your testimony. Do you believe that Cyclone has liability under B2?
Not based on what was in the record so far, but that portion of the statute was included in case anything came into evidence throughout the course of the hearing.
Okay. Have you been involved not only in this hearing here today, but all the discovery and the pre-filed direct testimony of the various parties?
The pre-filed testimony, not necessarily all of the discovery.
Okay. But you have nothing to bring before the commission here today that would impose liability on Cyclone or any of the Haver entities under B2, do you?
I do not.
Okay. Let's talk now about B3. The person that most recently accepted responsibility for the well by accepting an assignment or by signing an agreement or other written document between private parties in which the person accepted responsibility. Would you agree with me? Are you a lawyer?
Yes.
Okay, so I can ask you questions about legal conclusions. So that sentence, would you agree with me that that sentence, the person that most recently accepted responsibility for the well by accepting an assignment or by signing an agreement or other written document between private parties in which the person accepted responsibility requires a writing. Not a
Yes,
verbal communication, but it requires a writing, correct?
correct.
And that's consistent with the statute of frauds. It's consistent with all kinds of things. Then there's the next sentence. Accepting an assignment of a lease, obtaining a new lease, or signing an agreement or any other written document between private parties shall not in and of itself create a responsibility for a well located upon the land covered thereby, unless such instrument adequately identifies the well and expressly transfers responsibility for such well. Where is the document between McCorgry and Haver which expressly accepts responsibility by Cyclone or Haver to plug these wells?
You go back to the original lease between the Swaim Trust and Mr. McGorgery and the clause that identifies the 3 wells that need to be either produced or plugged prior to a new well being drilled. At the time that that lease was taken, there were only 3 wells on that lease. So I think that that is expressly or adequately, I should say, identifying those wells. And then the clause that says that no well shall be drilled until those wells are either produced or plugged. I think that that says that that accepts transfer or of responsibility. And further, once the well is drilled and there's the transaction, the transfer from Haver, or I should say Cyclone to Endeavor, one of those 3 wells is included in the transfer, which I think you can go to say infers that there was an understanding that Mr. Haver, or Cyclone, I should say, took responsibility for those wells, and they expressly transferred that one after the fact because they knew that they had the responsibility and could transfer it.
Okay, I want to go back now to my question. The sentence says, accepting an assignment of a lease, obtaining a new lease, or signing an agreement or any other written document between private parties shall not may not, but shall not, in and of itself create responsibility for a well located upon the land covered thereby, unless such instrument. The language must be in the assignment of the lease in order for it to impose that obligation. Where is the language in this assignment where Mr. Haver or Cyclone expressly accepted responsibility to plug wells?
The responsibility, or I guess I'm trying to phrase this the correct way to answer your question, but it's incumbent upon the operator who takes the assignment to know what is in the actual lease. How do they know what they're taking if they haven't had an opportunity to review that lease? And if they don't, then it's buyer beware. They're not taking their due diligence to examine what exactly they're taking on. They're just saying, okay, we'll take the Swaim lease. So that's where it's there. I mean, if they wanted to indemnify themselves, they needed to read the original lease.
I'm going to
Not
go
just
back.
blindly accept the
Ida, would you please put up the assignment of lease, which is Haber Exhibit 104? Mr. Hoffman, here, this is the assignment. Where in this instrument, which is what the statute requires, where in this instrument does Mr. Haver or Cyclone assume the obligation to plug the 2 wells that are the subject of this controversy?
The language that he assumes all right and title in that lease that is recorded there. That means that he needed to, if he's going to accept all responsibility for that legal document, he needs to understand what's in that legal document. And if he refuses,
show me the language you're referring to.
all right and title. It's right there, right above the highlighted 2002.
Just bear with me. I want to catch up with you. Okay. So Sundance. Well, the language is Martin McCorgry, assignor, does hereby sell, assign, and transfer and set over unto Sundance all right, title, and interest. Where does it say that Sundance or Cyclone or Haver assume any obligation of Martin McCorgry?
Well, if they're taking all right and title in the lease document, and the lease document explains what all right and title included, which meant that no well could be drilled without any other action being taken towards the 3 existing wells.
And in your opinion, as a lawyer and as an officer of the court in some respects, that instrument adequately identifies the well and expressly transfers responsibility for such well?
I think
that's your
that
opinion.
My opinion is that this instrument adequately identifies that they needed to do their due diligence and look at the original instrument that they're taking responsibility for, that they're accepting.
And in your opinion, this assignment expressly transfers responsibility for those 2 wells.
In my
That's
opinion,
your legal opinion.
My legal opinion is that the original lease expressly does that, and they accepted
That's not
an
the
assignment.
question. That's not the question. This assignment is the instrument at issue under the statute.
Well, this assignment
Where
transfers
in this
the lease.
instrument?
This assignment
Where in
transfers
this
that
instrument?
lease. The part where it
Where
says
in this instrument?
Objection, badgering the witness.
Yeah, I think we've got asked and answered. I think I've heard an answer from Mr. Hoffman that he believes this instrument does expressly identify, by referencing the original lease, if that was my understanding.
I apologize to the extent I was seen as badgering the witness. We were talking over each other because of the Zoom, and I was trying to focus on this assignment. The chair has interpreted your testimony. Is that a correct interpretation of your testimony, Mr. Hoffman?
yes.
Okay. I have no further questions of this witness.
All right, let me look at my list here. Mr. McCorgry, do you have any questions of Mr. Hoffman? And we can pull down the document, I believe.
No, do you hear me?
Yes, we hear you.
No, I have no questions for him. I have one comment. I'm sure you all don't realize how many head of cattle 1,900 head is. I have 1,500 head on my property, and I fed 500 of them, and I'm usually till dark every night anyway. I'll accept any responsibility that the Corporation Commission determines. I would like relieved of this so I can go tend my own business, taking care of my cattle. I can see sitting here all day and you all arguing back and forth. I have business to attend to. I accept responsibility if you determine that I should plug them, which I don't think I should, but that's for the courts to decide.
Well, we'll pause Mr. Hoffman's testimony here for a second. Mr. Hoffman, you may stand at ease. Let me just ask if the other 2 parties have any objection to Mr. McCorgry being relieved.
No objection from Cyclone.
I don't know that staff has an objection. If I can ask one question before he goes.
Would you like him sworn in?
Yes, please.
All right. Well, I don't know if there's any rules against swearing in 2 people at the same time, but Mr. McCorgry, would you quickly raise your right hand for me? Do you swear or affirm the testimony you give today is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, I'm going to have staff give an opportunity to ask you a couple questions, and then we will relieve you.
Thank you. Hello, Mr. McCorgry. My main question is, did you ever produce from either the SWAIM 1 or the SWAIM B1 while the SWAIM lease was in your possession?
No,
Okay. And the 3 wells that are referenced in the original lease agreement, those are the 3 SWAIM wells, correct?
yep,
Okay. Thank you. No further questions.
yep.
Thank you, Mr. McCorgry, and I do know how many cattle that is. My family has run a cow-calf operation of about 100, which seemed like a lot. So understand that responsibility.
Thank you.
With that, you are relieved and you may step down, and we will, I suppose the parties and our presiding officer will keep you abreast of these proceedings. So thank you for your time today.
Thank you.
All right, we will return to the examination of Mr. Hoffman. Thank you, Mr. Hoffman, for allowing that brief interlude. I believe we are ready for commissioner questions. We will turn to, well, do either commissioners have questions of this witness? I see a no from Commissioner Keither, and I see Commissioner Keen has gone off of mute, so I will turn to Commissioner.
Yes, thank you, Chair French. Very briefly. Good morning, Mr. Hoffman.
Good morning.
If you could, for the record, kind of clarify what role and to what extent do the T1 transfer forms bear on your conclusion that Cyclone is a responsible party for the 2 wells of concern in this docket?
Sure. If you go back to, as I was saying, the original lease agreement said that those 3 wells needed to be either returned to production or plugged prior to a new well being drilled. Cyclone drilled a new well, thereby essentially accepting responsibility for those wells, at least in our opinion, staff's opinion. And then when they transferred the lease and the wells to Endeavor, they only included one of those 3 wells, which meant they did not transfer the SWAIM B1 and the SWAIM 1 to Endeavor. It remained their responsibility to plug those 2 wells.
Very good. And so I follow on to that answer. To what extent, if any, under the circumstances, including even documents that were reviewed with the cross-examination of Mr. Clark, to what extent, if any, do you presently believe that Endeavor has any responsibility for plugging either or both of these wells?
I don't believe that they have any, because if you go back to the last phrase of the is it B2 that says that just taking the lease or the assignment doesn't make them automatically responsible for those wells. And the fact that the transaction between Cyclone and Endeavor included one of the 3 wells, I think showed their intent of which well they were taking from Cyclone.
Okay, very good. I will ask one other question, tangentially related to your division's review of these T1 transfer forms incidental to the transfer of lease responsibilities. As a matter of public policy, am I safe in saying that review process is important because it will identify from the wells that the transferor operator has accepted responsibility for, those wells that the transferee is willing to accept responsibility for, and in the event that the 2 don't match, that there are some wells that are deleted, it would give rise for at least some question by the division about the circumstances and why it was that was the case.
Yes, and as a means to try to get to that end, one of the things that staff started doing with the processing of T1 forms was requiring some sort of legal document that showed which wells and which land covered by the lease was transferred to the new operator. That was a requirement that came out after the Denman case.
Okay. And if not to, I'm going to try to be somewhat simplistic here for my own benefit, but basically in the whole process of this, you're trying to make sure that there is some acceptance of responsibility for each and every well to which you can assign responsibility uh, 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 throughout the state. Isn't that correct?
That is correct because we have limited state plugging funds, and I think we have a fiduciary duty of sorts to make sure that we use those funds properly and that we pursue potentially responsible parties when they exist.
Very good. Thank you for your indulgence in my questions. I have no further questions.
Okay, I have a question and it's gonna be belaboring a point and you may have already been asked and answered, but I want to make sure I understand it. So the only time that this express language occurs in a document about the plugging responsibilities is in the original lease document when it was assigned to Mr. McCorbury. But that lease in its entirety was assigned to look like Sundance, eventually becoming Mr. Haber. And so staff's contention is, look, that those responsibilities, that condition, because it was assigned in its entirety, those responsibilities were assigned to Mr. Haber. I don't have the document in front of me where the well was assigned to Endeavor, but my understanding of staff's position is that it only singled out a specific well. It didn't make reference to the entire lease as the previous did, and so it doesn't expressly incorporate the responsibilities for the abandoned wells or the non-producing wells. Is that correct? That is the distinction you're making, is that the assignment to Endeavor was specific, and so it did not include that condition, which was part of the original lease.
I wouldn't say the assignment was specific. I would say that the transfer was specific. So the operator responsibility that is subject to which is why the T1 is filed, and that was specific as to which wells were going from Cyclone to Endeavor.
But doesn't the whole crux of this argument, it doesn't rest on who filed the T1 and who put something on their inventory. It goes to where people accepted responsibility in lease documents and tracing back the assignment of those documents, correct?
And the actions associated with those companies after the documents were accepted. Because I think you could say, well, you could look at just the paper trail, or you could look at the fact that they actually drilled the well. Cyclone drilled a well, which is one of those conditions that's listed in the lease. No other party after them drilled that well.
Mr. Chair, the Swain lease that you're referring, the assignment from uh, Endeavor, or excuse me, the assignment from Newcomet to Endeavor at Exhibit JK8. This was page 15 of 19 in the pre-filed direct testimony of Jeff Clock. Specifically assigns the entirety of the lease from Newcomet to Endeavor. It references the Swain lease dated July 18th, 2002.
That's right.
And it's
Thank you.
Exhibit JK8, page 15 of 19.
Okay. Thank you for that clarification. I knew we had seen that language earlier, so that is helpful. Yeah, so I think, Mr. Hoffman, that is what I keep coming back to is
Would it be possible
the,
to have John pull that up?
yeah, that'd be good.
One moment.
Thank you, John.
JK 8, page 15 of 19. And it says the Swaim lease, it does have Sundance number 7 in parentheses, and then it does list where the lease is recorded in the Office of Register of Deeds.
Right. And then if you look at this in the context of the statute and it talks about just merely transferring or taking the assignment doesn't make somebody responsible for wells when they clearly state on here Sundance number 7, which is the name of a well that they drilled. And then they transfer one of the wells that was existing and not plugged and not addressed by Cyclone before they transferred it. I think that's where you can make a distinction between just the entirety of the lease.
So it's your contention that by putting Sundance number 7 in parentheses, that it was not the intention to incorporate the entirety of the lease in this assignment.
Yes, because that adequately identifies a single well that they're transferring.
Okay. I think that answers my question. I just wanted to make sure I understood exactly how the parties are slicing their interpretations of these documents and how the statute might apply to different transactions. So I see Commissioner Keene has gone off a mute, so he'll relieve me for a moment. Commissioner Keene, if you'd like to ask a question.
Yes. Mr. Hoffman, to the extent I make any misstatements in asking this question, you should feel free to correct that. But if I understand the staff's position here, it is that there is basically a rule of construction in reading these documents that to the effect, and I may poorly state this, but I'm going to do my best, that when, as in the assignment, it references all right, title, and interest, that is a shorthand way of accepting all the terms of the lease as it was originally drafted. And is it not also correct that the reason that these leases and assignments are all subject to the recording acts is to provide public notice to the world about the terms of relationships as they involve the particularities of the facts involved within these transactions, such that what you basically have here is would it have, is it the staff position that it would have been no more necessary for the assignment to recite other paragraphs of the lease individually, since by reference they were all incorporated into the assignment by reference to all right, title, and interest?
That is correct.
Question
Yes.
mark. All right, no further questions. Thank you.
Yeah, I don't believe I have any additional questions as well. Mr. Marsh, is any redirect necessary?
I don't believe so. I think the question I'd ask has been asked about 3 different ways. So I think I don't have anything.
Okay.
Different.
All right. Well, I think because we didn't go down the path of redirect, we will just conclude with this witness right there. So, Mr. Hoffman, thank you very much for your testimony today. You may step down virtually.
Thank you.
All right. We've been going a little while now. Let me look at my schedule. I think we've relieved the need to examine Mr. McCorgry as we've let him be relieved of the hearing. So we only have Mr. Haver and Cyclone. Let's take a brief break and then we will move to Cyclone to call their witness. But let's take a 10-minute break this time. I've got 11:09. Let's break until 11:20, and then we will hope to complete all the testimony before noon or around noon. So we are now off the record. We will reconvene at 11:20. All right, I have 11:20. I see Commissioner Keither is here. We have Mr. Hartman. We've got Commissioner Key. Mr. Myers, you are here for the moment. I know you've been having some technical difficulties to say the least. Some power outages and internet outages, but we'll see if you can hang on as long as you can. All right. Looks to me like we've got all the important players here. So we are ready for Cyclone. Mr. Hartman, would you like to call your witness?
May I make a record?
Yes, you may.
First, Cyclone would demur to the evidence on any claim that Cyclone has any liability under the statute at subparagraph B2, because there has been produced no evidence that Cyclone was the most recent operator to produce from or inject or to dispose into either of the wells that are the subject of this proceeding. Second, Cyclone would object and demur to the evidence on the basis of the fact that Cyclone there has been produced no document under which Cyclone Petroleum has accepted responsibility for the wells that are the subject of this litigation, to the extent that staff points to the assignment of oil and gas from Martin McCorgry to Sundance, Haver Trial Exhibit 104, that is not Cyclone, and therefore Cyclone demurs to the evidence on that basis. Then, in addition, Cyclone demurs to the evidence on the basis of the fact that the truly responsible parties, who are the persons that most recently accepted responsibilities for the wells, are Newcomen Exploration and Endeavor and Redbud, as evidenced by the documents that have been admitted into evidence. Thank you, Mr. Chair.
So I understand that is your position. Are you making a motion for summary judgment at this time, or are you just laying out your position?
And I'm sorry, I'm more of a jury trial person than a commission lawyer. And normally what happens is when the plaintiff rests, I demur to the evidence, meaning they have not established a prima facie case. So it may, in fact, be a motion for summary judgment.
Yes.
In the eyes of the commission.
That's certainly fine. Yes, it's a little different procedure here. But any response, Mr. Marsh?
No, I think a lot of those assertions are incorrect. I mean, we've already had evidence here that Cyclone accepted, or Cyclone/Sundance, it's basically the same company, accepted the lease from Mr. McCorgry and was subject to the terms of that original lease, which included taking responsibility for the wells if a new well was drilled, and they drilled that new well. So I think that there's motion for summary judgment, or whatever we want to call it, should be overruled or denied, or whatever, and we should continue on.
Yes, I will deny the motion on the grounds that I believe we do have a dispute here. I think it would benefit the commission to receive the finality of the evidence and to receive legal briefing on this issue. So I will deny the request at this time, and then the commission will proceed with a final order following the hearing. So Mr. Hartman, you may now proceed with your witness.
Is the witness sworn?
No, I will swear him as soon as you call him.
I called Jim Haver.
Mr. Haver, will you please raise your right hand? Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Hartman, you may proceed.
I'm sorry, state your name for the record, please.
James Malcolm Cecil Haver.
And are you the same James Malcolm Cecil Haver that submitted pre-filed direct testimony on behalf of Cyclone Petroleum Incorporated on June 30 of 2025?
Yes.
And have you had a chance to review that pre-filed direct testimony
Yes.
prior to this hearing?
Yes.
And do you have any corrections to make with respect to that testimony?
I do not.
Is that testimony true and correct to the best of your knowledge and information?
Yes, it's
At this time, we'd move admission of the pre-filed direct testimony of James Haver on behalf of Cyclone Petroleum Incorporated dated June 30, 2025.
Is there any objection?
No objections other than the exhibits, which staff, we've already gone through. So,
Given that, I will admit the reference testimony into the record.
And I guess I'd like to understand, does that include the exhibits that were attached to the testimony? The admission into evidence of the exhibits that were attached to the testimony?
Yes.
Okay, great. Thank you. Mr. Haber, you've been present during this proceeding and heard some testimony from staff concerning this matter. And I'd like to ask you a few questions about that testimony.
Mr. Hartman, one point of process here. We typically do not allow additional direct examination aside from the pre-filed testimony. So I will admit, looking back at the procedure here, this proceeding is a little different in that we had a procedural schedule and then we joined another party, Mr. McCorgery, before we elicited staff's testimony. So I'm inclined to maybe give a little leeway if there is some additional clarification needed. But we do not typically allow additional direct examination just in response to the other live testimony that you heard. So I will give a little leeway if you think there is any clarification of the record that's needed, but hopefully it is not extensive.
Well, I think part of what I want to, and I apologize for being an amateur in this forum.
You're absolutely fine, and that's a rule that not everybody knows about, but it is in our regulations.
I want to make sure I understand the latitude that you're giving me, the parameters. For example, during the course of this proceeding, there has been a great deal of testimony outside of the pre-filed testimony of staff representatives that I would like Mr. Haver to be able to respond to. There's no way we could have anticipated some of the testimony that has been admitted into evidence from Mr. Hoffman and am I allowed to inquire about the subjects that they testified about?
Well, it's not an opportunity for just additional rebuttal. I mean, we have to cut off direct examination at some point, but if there is something very brief that you need to clarify the record on, I will allow it. We have the ability to flex our rules just a bit.
Okay, thank you. Well, I guess I should start with, we've got exhibits 101 through 110 already admitted into evidence. I would like to have the witness authenticate as a contemporaneous business record, exhibit 111. Would that be permissible?
Yes, that's fine. I was anticipating that you would lay some additional foundation.
Mr. Haver, I'm going to hand you what has previously been marked Haver Exhibit 111 and ask you if you've ever seen those documents before that email chain.
Yes, I have.
And are these contemporaneous business records that have been in your possession and have been reproduced for purposes of an exhibit?
Yes.
Your Honor, we'd move admission of Exhibit 111 at this time based on the relevance that's been established in the earlier testimony and the authentication of this witness and the exception of the hearsay rule for business records.
Mr. Marsh, any objection?
I believe this exhibit is already, as the commission has determined, will be admitted or denied admittance in the final order. So I don't know why we keep trying to re-admit the exhibit, but it has the same issue of this, we're talking about emails from 2011 that Mr. Haver has just said he's had in his possession the entire time. So I don't understand why these exhibits couldn't have been included in his direct testimony if they're so important.
Now that we have established relevance in the earlier testimony, we've authenticated the document at this time, so I do believe it is permissible to admit it, and I will admit this exhibit. I believe it's 111.
Yes, 111. And again, Mr. Chairman, to save time, Mr. Haver would authenticate exhibits 112, 113, and 114 and 115 as contemporaneous business records, and we'd move admission of the same. Mr. Haber, are these all contemporaneous business records?
Yes, there.
For clarification, are those all the emails that we went through before with Mr. Clock?
The emails that we went through, as well as, with referencing the pumpers, et cetera, and the Cyclone sale agreement between Newcomet and Cyclone.
Mr. Marsh, can I assume that your objections are similar to those raised before on these items?
Yes.
Okay, I will go ahead and overrule the objections, and we will go ahead and admit those exhibits. So just for clarity of the record, it is 111 through 115. Is that correct, Mr. Hartman?
Yes.
Okay.
111,
112, 113, 114, and 115.
Mr. Haber, Haida, would you pull up Haber Trial Exhibit 104? Mr. Haber, this is the assignment of oil and gas lease that is from Martin McCorgry to Sundance Oil and Gas. Have you ever seen that document before?
Yes.
Were you involved in obtaining this assignment? You personally?
No. We would hire either Fred Hambright or Bob Morgan as a landman working out of Wichita, and they would go out and get our leases.
Were you made aware prior to the time that you spudded the Sundance number 7 of the existence of the requirement in Haber Trial Exhibit 103, which is the original lease on the Swaim lease?
No, we would use this. We were in it, had a drilling program, and this was number 7 in the program, and we got our lease, and we moved to rig in, 30, 40 days later.
I
have no further questions of the witness.
Okay, thank you very much, and thank you for being brief. Okay, at this time, we will move to Mr. Marsh for cross-examination, if you have any cross-examination of this witness.
Yes, thank you, Chair French. Good morning, Mr. Haver. Your companies obtained the Swaim lease on August 1st, 2002, correct?
He testified that's correct.
Yes, that is correct.
Okay. And you were assigned that lease that was originally between Mr. Swaim and Mr. McCorgary, is that correct?
Objection as to you ask for clarification.
Yeah, Hambright,
Mr. Marsh, can you clarify what entity you mean by you?
Well, Mr. Haver's companies were assigned the lease that was originally between Mr. Swaim and Mr. McCorkery, correct?
yes, the landman turned in a lease between Martin McCorkery and Sundance Oil and Gas. And it's dated August 1st, 2002.
And I'm going to pull up a copy of the lease. I think this one's from Exhibit JK3. Mr. Haver, it says that that lease was recorded in book 654, page 521. Is that correct?
Or 655, 480. I have on mine, it says book 655, 480.
Right at the bottom of the page. But I'm talking about the lease from Mr. McCorkery. The lease assignment is recorded in book 654, page 521, and that's included on the lease between Mr. McCorkery and Sundance Oil and Gas, correct?
Do you mind if I show the witness what you're talking about?
No, that'd be fine.
Oh,
You see there's an assignment down here.
oh, here.
Yeah, right there, 654, 521.
I do see that, yes.
Right.
Okay. And then Cyclone Petroleum spud the Swaim Sundance number 7 on September 26, 2002, correct?
That is correct.
Then in 2011, Cyclone Petroleum assigned the Swaim lease to Endeavor Energy Resources, correct?
Yes, that's correct. We assigned the whole lease with a number of other leases.
Okay. And I'm going to pull up Exhibit JK 7. Mr. Haver, do you see the document that I pulled up?
Hold on. I don't.
Bear with me just a second. Let me find it. I'm sorry, what did you say, JK7?
JK7.
Yeah.
It's the request for change of operator form.
Okay, I have it.
Okay. And that's T1 between Cyclone and Endeavor Energy Resources, correct?
Cyclone 2. Yes, that's correct.
And the effective date of that transfer was September 1, 2011.
That correct. Yes.
And your signature is next to Cyclone Petroleum's name on that form, correct?
Yes.
Okay. Going down to page 2, there's 2 wells listed. One is the Swaim A1, which is 15-035-23678. And the Swaim Sundance 7, which is API number 15-035-24169. Is that correct?
Yes.
Okay. The Swaim number 1, API number 15-035-23624, and Swaim B number 1, API number 15-035-23712 are not listed on that T1 form, correct?
That's correct.
Why are they not listed on the form?
Well, we never produced them, never touched them, and maybe it was an oversight. We sold in this package 40, 50. I think there's 40 different leases, and it would have been myself and my secretary doing the paperwork, so maybe we missed it.
Okay, I'm going to bring up KAR 82-3-136, which discusses transfer of operator responsibility. Do you see that in front of you?
It's only on the screen.
Oh.
We've got some technical difficulties here.
I know he's a little bit far back, but
Can you read that? Yep. Okay.
and Mr. Haver, subsection A says, if operator responsibility is transferred, the past operator shall report this transfer to the Conservation Division within 30 days of the change upon a form prescribed by the commission. Is that correct?
Yes.
And subsection B says the past operator shall furnish a list of all active and inactive well bores on the lease unit, gas storage facility, or secondary recovery unit with the notice of transfer. Is that correct?
Yes.
Okay. And then in your testimony, you referred to a matter litigated between Cyclone and Endeavor in Sumner County District Court. Is that correct?
Yes.
And one of those exhibits / filings is a pre-trial order, correct?
Yes.
Which is attached as Exhibit 7, I believe, to your testimony.
Yes.
Okay.
Let's see. Oh,
I want to scroll down to page 5 and 6 of that exhibit.
I'm sorry, the pre-filed testimony of James Haver has exhibits F and G, and did you say it's exhibit F or what exhibit?
Exhibit F, page 5 and
what
6.
page? Page 5 of exhibit F.
Yeah, it's the bottom of page 5, mainly on page 6.
Okay, orphan wells plugged and abandoned.
Mr. Haver, is the SWAIM number 1 or SWAIM number B1 or B number 1 listed on that list of 33 wells?
um, what am I looking for?
We would stipulate that they are not on that list of wells.
Okay, thank you. I have no further questions.
Okay.
All right, thank you, Mr. Marsh. We will now move to commissioner questions. Commissioners, do you have any questions of this witness? Commissioner Keither, I see a no. Commissioner Keen, don't know if we've got Commissioner Keen right now. I'll wait just a moment. All right, I do not have any questions of this witness. Mr. Hartman, any need for redirect?
No.
All right. Well, at this time, I believe we've gone through all the examination. If there's no need for redirect, then Mr. Haver, you may step down. We thank you for your testimony today.
Thank you.
All right. Since Mr. McCorkery was already relieved, we will not be taking him up. I will note for the record, though, although we did not pull him up and ask him foundational questions, all of the foundation appears to be laid in his testimony, and so we are going to admit his pre-filed testimony into the record of this proceeding. Just wanted to note that for the record for the parties. So we will now move to closing statements. I understand we did not establish time limits, but I do think the parties wish to make closing statements. So I will just ask you to be succinct as possible, but I want to give the opportunity for closing statements from both Cyclone and staff. We will begin with Cyclone. Mr. Hartman, would you like to make a closing statement?
Well, Chair, if it's okay, since you have said that we can file proposed findings of fact and conclusions of law, in the interest of saving everyone's time and boring everyone with my rhetoric, if Mr. Marsh will agree, I would just pass on the closing arguments. I'd like to again move for directed verdict for the same reasons I articulated in my murder the evidence. But otherwise, I'd prefer to just submit my findings of fact and conclusions of law. That way I do it in an organized fashion and don't waste the court's time.
Thank you. Mr. Marsh, are you amenable to waiving closing statements in lieu of post-hearing briefing and the potential possibility of filing a proposed order?
Yes, Chair French.
All right, and I will deny the motion for a directed verdict, but we will move forward with an order following the legal briefing in this case. So with that, thank you. Appreciate the parties' willingness to move things along because we are going to have post-hearing briefing. I understand at the December 9th pre-hearing conference, the parties being Cyclone and staff have agreed to file simultaneous post-hearing briefs 30 days after receiving the transcript in this case. And I believe Mr. Myers will be in touch with you to make sure you do receive the transcript. And then you will have an opportunity to file simultaneous post-hearing responsive briefs 14 days after that first 30-day period. So I would just suggest that when Mr. Myers gets the transcript and delivers it to all of you, that he can clarify exactly what the due dates are for both of those briefs. And then to the extent you would like to file, I'll call it a proposed final order in the case, but findings of fact and conclusions of law. If you would like to file that, I would suggest it be filed with the responsive, your second brief, with your responsive brief. At the conclusion of the record. Is there any clarification to that procedural schedule that I've laid out?
Not to the procedural, but I would like, if you don't mind, Chair, if you would help me understand what exhibits remain not admitted into evidence, or what I need to do I need to file a motion?
I believe we actually, I believe unless someone wants to clarify for me, and Mr. Myers and Mr. Marsh, I might look to you to see if you have any disagreement, but I believe we have admitted everything into the record or taken official notice of the items you asked for, which would be everything. I believe it was exhibits 101 through 120, all in. I know you were able to identify the KCC proceedings that you wanted us to take official notice of, and we did take notice of those. And we did go ahead and admit the exhibits that you were eventually able to lay a foundation for with both Mr. Clock and Mr. Haber. Is there, I will rely on the parties if there is anything I missed, but I believe everything that was presented to us has been admitted or taken official notice of.
That was my understanding, Chair French. I appreciate it. Thank you very much.
Okay. All right. With that clarification, I would just encourage the parties to be communicating with Mr. Myers if there are any questions about the post-hearing schedule. And I believe he will be in touch once we have a transcript of this proceeding. If there are no final post-hearing issues from the parties or the commissioners, I will go ahead and conclude the hearing. And at this
May I
time,
ask one more question? May I
yes,
ask
you
one
may.
more question?
Absolutely.
Is it ever possible to settle one of these? I mean, is it possible to settle this?
I'll tell you my personal philosophy. Different commissioners are different on settlement. I personally don't have any heartburn if the parties want to get together at any time before, during, or after hearings, and they want to make some agreement for the commission's consideration. Personally, I will always consider that. But to me, that's between you and the staff and the parties to this proceeding. And if there is something you want to bring before us, I would just suggest that be brought in writing, but I'll leave that to discussions between yourself and Mr. Marsh.
Thank you.
Absolutely. All right. Any further final questions, clarifications, matters for the record?
Nothing from staff.
Okay. Hearing none, this does conclude our hearing in this docket. At this time, we will close the record and adjourn. Thank you all for your participation in the hearing today.
Thank you.